The court said, "Not guilty." The public said, "She got away with it." But by the time that verdict was read, millions had already decided she was guilty. For 3 years, cameras didn't just follow the case. They built the narrative. So here asked the real question. Did the jury fail Justitia? Or did the media decide the outcome long before the law did? Before the jury ever entered deliberations, the case had already become a national obsession. What started as a missing child investigation quickly transformed into a 24-hour media cycle. News vans parked outside the home. Reporters broadcasting live updates with almost no new information. Every silence filled with speculation. Cable networks ran countdown graphics. Panels debated motives before charges were even finalized. Legal analysts argued theories that hadn't yet been tested in court. Viewers weren't just watching a case unfold. They were watching a story being shaped in real time. Language matters. And the language shifted fast. In the early days, coverage centered on the search. Hope. Urgency. Sympathy. But as inconsistencies appeared in interviews, tone changed. Words became sharper. Headlines more definitive. What had been uncertainty turned into suspicion. What had been questions became conclusions. And the audience followed. Social media amplified everything. Short clips were replayed without context. Emotional reactions were dissected frame by frame. Every facial expression became evidence in the court of public opinion. The more coverage expanded, the more the narrative narrowed. There is a psychological effect at play here. When people hear the same framing repeated often enough, it begins to feel like established truth. Even without a verdict. Even without full evidence presented. By the time the trial formally began, millions believed they already understood what had happened. Not because they had read forensic reports. Not because they had sat through pre-trial motions. But because they had absorbed a storyline. And storylines are powerful. Television rewards clarity. Heroes and villains. Simple arcs. Emotional closure. But the legal system does not operate on emotional clarity. It operates on proof. On burden. On reasonable doubt. That gap between narrative certainty and legal uncertainty is where tension began to build. As coverage intensified, pressure grew. Not on the public. On the courtroom. Jurors were instructed to avoid media. To remain neutral. To consider only evidence presented inside the courtroom. But they knew the world outside was watching. The trial was no longer just a legal proceeding. It had become a cultural event. And once a case becomes cultural, neutrality becomes fragile. The question isn't whether the media reported the case. The question is whether constant exposure reshaped what people expected the outcome to be. Because expectation can quietly become demand. And demand can quietly turn into outrage. By the time closing arguments were delivered, the narrative outside the courthouse felt settled. Inside the courtroom, however, something very different was happening. Inside the courtroom, the atmosphere was very different from what people saw on television. Jurors were not allowed to consider headlines. They were not allowed to consider public outrage. They were not allowed to consider what awful obvious. They were instructed to consider only one thing. Evidence presented in court. And that evidence was not as simple as the public narrative suggested. There was no direct witness. No confession. No clear forensic link placing intent beyond reasonable doubt. The prosecution argued motive. They argued behavior. They argued inconsistencies. But inconsistency is not the same as proof. In criminal law, the burden is not a euro most likely a euro. It is not a euro o emotionally convincing a euro. It is not even a euro morally disturbing a euro. It is proof beyond reasonable doubt. That standard exists for a reason. Because once you lower it, you don't a euro just convict the guilty a euro. You risk convicting the uncertain. During the trial, forensic testimony was challenged. Timelines were questioned. Digital evidence was debated. Experts disagreed. And when experts disagree, doubt expands. The public often hears disagreement as confusion. But in a courtroom, disagreement can be enough to fracture certainty. Jurors deliberated for hours. They did not debate public anger. They debated whether the prosecution had removed every reasonable alternative explanation. That is a much narrower question. The prosecution had to prove not only that a tragedy occurred a euro, but that the accused was criminally responsible under specific charges. Not suspicion. Not character judgment. Not emotional reaction. Specific charges. And here a euro as something that rarely makes headlines. A jury can believe someone acted poorly, lied, or behaved strangely a euro, and still conclude that the legal threshold was not met. That distinction is uncomfortable, because it separates morality from law. And when those two drift apart, outrage fills the space. When the verdict was read, many people believed justice had failed. But from the jury a euro's perspective, the question was never, a euroito we think something terrible happened, a euro. The question was, a euro did the prosecution eliminate reasonable doubt, a euro? If the answer to that question is no a euro, the law does not allow conviction. Not because the system is weak, but because the system is built to tolerate doubt. And that design is intentional. Outside the courtroom, something else had already happened. The verdict wasn't a euro the beginning of outrage. It was the trigger. The outrage had been building for years. When a case dominates headlines long enough, people stop observing. They start identifying. You a euro not just watching. You a euro choosing a side. And once you choose a side, doubt feels like betrayal. Television doesn't a euro reward doubt. It rewards certainty. Strong statements. Confident experts. Clear villains. Clear motives. A euroethos is obvious. A euro. A euroianian can see it. A euro. A euroeth evidence is overwhelming. A euro. But a euroobvious a euro is not a legal standard. Repetition creates confidence. Confidence feels like truth. And truth a euro once repeated enough a euro feels undeniable. Clips get replayed. Expressions get dissected. Silences get interpreted. Behavior becomes evidence. Tone becomes motive. Suspicion becomes conclusion. And slowly, the narrative hardens. By the time the trial reached its final days, many viewers were in a euro waiting to learn the outcome. They were waiting to see it confirmed. Theta euro s the difference. The public wanted confirmation. The law requires proof. Those are not the same thing. Inside the courtroom, jurors were asking, a euro has the burden been met, a euro? Outside the courtroom, the question was different. A euro, how could it not be a euro? That gap a euro between legal doubt and emotional certainty a euro is where tension explodes. If you hear for months that guilt is clear, then a not guilty verdict doesn't a euro feel neutral. It feels wrong. It feels like failure. It feels like corruption. But feeling is not a statute. And here euro s the uncomfortable layer. High-profile cases don't just inform the public. They condition the public. When analysts speak with confidence. When debates frame conclusions as inevitable. When headlines escalate language over time certainty becomes the default position. Mother. Suspect. Liar. Monster. Labels move faster than evidence. By the time closing arguments began, many people were evaluating testimony. They were defending a belief. And belief resists contradiction. Jurors are instructed to ignore media, to ignore noise, to ignore pressure. But the world outside does not ignore anything. The courtroom becomes a stage. The trial becomes an event. And expectation becomes demand. Demand for closure. Demand for accountability. Demand for a result that feels right. But the legal system is not designed to deliver what feels right. It is designed to deliver what can be proven. And that design is frustrating. Because doubt looks weak. Certainty looks strong. Media environments reward strength. Courtrooms reward restraint. So when a verdict clashes with public confidence, people don't ask whether the standard was met. They ask why the system failed them. Maybe the deeper discomfort isn't about guilt or innocence. Maybe it's about this. The public had certainty. The jury had doubt. And in a courtroom, doubt wins. When the verdict was read, outrage spread faster than the legal explanation ever could. People did not ask to see the jury instructions. They did not ask to read the full trial transcript. They asked one thing. How could they let her walk, But that question hides another. What if the jury did exactly what they were instructed to do? What if the legal system did not fail but functioned precisely as designed? The standard is not emotional satisfaction. It is proof beyond reasonable doubt. And that standard exists to protect everyone including people the public dislikes. That is the uncomfortable part. Because protecting the unpopular is not emotionally rewarding. It feels wrong. It feels unjust. It feels like something slipped through the cracks. But lowering the burden of proof does not only affect one case. It affects every case that follows. Here is the harder question. When we consume a trial as entertainment do we begin to expect narrative closure instead of legal precision? Television gives us arcs. Mysteries resolved. Villains exposed. Endings that make sense. Courtrooms do not guarantee that. Sometimes the result is uncertainty. And uncertainty is intolerable to an audience that has already decided. So when people say, ETH system failed what they may actually mean is, ETH outcome did not match my expectation. Expectation is powerful. If you watched months of coverage, if you heard confident commentary, if you absorbed repetition framed as fact, then a contradictory verdict feels like betrayal. But betrayal of what? Justice? Or the narrative we believed? Here is the line that separates emotion from law. The legal system is designed to avoid wrongful conviction even if that means some cases end without moral closure. That design frustrates people. And frustration turns into anger. But anger does not automatically mean injustice occurred. It can mean the system prioritized doubt over certainty. That distinction is uncomfortable. Because doubt feels like weakness. Certainty feels like strength. And media environments reward strength. Strong claims. Strong opinions. Strong conclusions. But the courtroom rewards restraint. Measured language. Precise definitions. Burden of proof. When those two worlds collide, media certainty and legal doubt, someone will always feel cheated. Maybe the deeper issue is not whether the jury failed. Maybe the deeper issue is whether we expect trials to confirm our beliefs. If a jury verdict contradicts public consensus, is that proof of corruption, or proof that the legal standard is harder to satisfy than public opinion? That question does not have a satisfying answer. And maybe that is the real source of outrage. Because outrage often fills the space where closure is missing. The system may not have delivered emotional justice, but it may have delivered procedural justice. And those are not the same thing. So the final question is not whether you agree with the verdict. It is this. Do you want a legal system that follows evidence, even when it disappoints you? Or do you want one that delivers the outcome that feels right? Because you cannot design a system that guarantees both. And in that tension, between feeling and proof, is where this case will continue to live. There is one more uncomfortable layer to this story. Trials are not designed to satisfy public emotion. They are designed to test evidence. But when a case becomes cultural, that distinction blurs. People don't just want a verdict. They want reassurance. They want confirmation that the system sees what they see. And when that confirmation doesn't come, trust begins to crack. But here is the danger. If public outrage becomes the metric for justice, then the loudest reaction starts shaping expectations. And expectation, repeated often enough, turns into pressure. Pressure on prosecutors. Pressure on jurors. Pressure on judges. The legal system was built to resist that pressure. Not because it protects the guilty, but because it protects the standard. Beyond reasonable doubt. That phrase sounds technical, cold, detached. But it is deliberate. It exists because history has shown what happens when certainty replaces proof. So the real tension in this case may not be about one verdict. It may be about this. Do we want trials to confirm what we believe? Or do we want them to challenge whether belief is enough? Because those are two very different systems. One gives closure. The other gives protection. One feels right. The other demands restraint. And when those collide, someone will always walk away angry. The question is not whether you agree with the outcome. The question is this. If the evidence doesn't remove doubt, are you willing to accept that doubt? Or does outrage feel safer than uncertainty? Because in that answer, you reveal what you think justice is supposed to be.